Good morning, it's 9:31, so I will kick off. Thank you very much for joining our webinar this morning, hosted by myself and my colleagues Tom and Mustafa. We are going to talk to you about the Infrastructure Wales Bill this morning, and before we kick off, if I can just deal with a few housekeeping matters. We will have a Q&A session at the end of the webinar, and if you have any questions that you would like to ask us, can I please ask that you add these to the Q&A function on the Zoom call. If you have any technical questions, my colleague Megan is also on the webinar, and if I can ask that you put those into the chat, Megan will pick those up and she will help you to resolve them. I think that's all I need to say on that for now, so I will move on to the main presentation. Hopefully the slides will let me. Hopefully those of you who joined the webinar this morning are fully familiar with us and have hopefully worked with us, but just in case you're not, it would be remiss of me not to explain who we are and what we do. We are BB Pitmans. We are a law firm based in London in the southeast, and across the firm we have a strong focus on infrastructure, but in particular we have a large team of infrastructure consenting lawyers, and all three of us are part of that team, and we work heavily in this sector, working on a large number of projects across England and Wales and indeed in Scotland. On the map there we have some pins showing some of the projects we've worked on in recent years, and we've also highlighted on the slide some of the major projects that we've worked on recently, particularly national significant infrastructure projects in England, and also a number of DNS projects in Wales, as well as across other consenting regimes in both countries. So in terms of what we're going to talk about today, I'm sorry, there just seems to be a bit of a lag on the slides, so apologies if it's a bit clunky. We're going to talk about the new bill that's been introduced to the Welsh Parliament, and I've got at the top of the slide there the shorthand description of this bill: an act to reform the law governing the development of significant infrastructure in Wales and the Welsh marine area. Now, I expect a lot of you on the call are involved in Welsh projects and advising on infrastructure in Wales, and if so, you're probably fully appreciative of why this act is being required and why they are looking at resolving the current consenting regimes in Wales, because it's fair to say they're fairly complex. And what we're going to do today is we're going to talk about some of those complexities in section 1, the context behind the bill, while this is considered to be required, and Tom is going to speak about that. Then we're going to move over to Mustafa, who's going to explain what the new requirements are and the types of project that will be caught by them. Then I'm going to say a little around the new process that the bill prescribes for and the timescales that will apply to it. And finally, we're going to say a little about the legislative process that the bill will now go through, and in particular the opportunities that you may have to influence that process if indeed this is something you'd like to do. So without further ado, I will hand you over to my colleague Tom, who's going to talk about the background to the bill.
Thank you very much, Sarah, for that introduction. So just in terms of setting the context to the bill, it was introduced on the 12th of June 2023, but actually we need to go back 5 years to understand the genesis of the proposals that we now find in the bill. And in April 2018, Welsh Government undertook a consultation on proposed changes to the consenting infrastructure in Wales. And the proposals in the bill reflect the long-term objectives described in that consultation. And what the outcome of the consultation found was that there was a need for a comprehensive overhaul of the consenting regime in Wales. And anyone who has had the misfortune of advising or considering the consenting position in Wales will know just how complicated the regime can be, with numerous overlapping consent regimes applying for different types of project. And what the bill tries to do is to create a one-stop shop to replace the range of existing consent regimes that exist. And one of the key things that this bill would do is replace the developments of national significance, the DNS regime, that was introduced by the Planning Wales Act in 2015. And the DNS regime is in effect an application to the Welsh ministers for a large-scale planning application for certain infrastructure projects. But what the 2018 consultation found was that that regime, the DNS regime, was not fit for purpose. And there are a few reasons for that and a few findings from the 2018 consultation which lead to that conclusion. In particular, the DNS regime is not competent to deal with projects in the offshore marine environment. And the reason for that is that as a planning application, the jurisdiction of the Welsh ministers stops at low water mark. So anything the other side of low water mark falls outside the DNS regime. The DNS regime does not capture certain types of consent either. So large-scale highways and harbour projects fall outside the scope of the DNS regime. And third, and perhaps most importantly, developments of national significance are simply a planning permission. So they do not deliver the range of other consents that are often needed to give effect to an infrastructure proposal. If we take, for example, an overhead line in Wales that falls within the DNS regime, often the promoter of that scheme will also require compulsory purchase powers over land. However, those powers would need to be secured by alternative means via a CPO under the Electricity Act 1989. So we can see that we have a regime at the moment that gives rise to overlapping and a multiplicity of different consents. And what this bill is trying to do is to consolidate within a single instrument a large number of consents that you would need to deliver a project. And in that sense, it's fair to describe this regime as a mini DTO regime for Wales and Welsh waters, up to 12 nautical miles. And there are some changes in terminology from the DCO regime that many people, I'm sure, will understand and know under the Planning Act 2008. So whereas it's development consent for nationally significant infrastructure projects in England, in Wales, it's infrastructure consent for significant infrastructure projects. So why now? Because I mentioned a moment ago, and I'm just waiting for my slides to catch up. I think we're there now. So why now? Because the consultation that I mentioned took place in April 2018, some 5 years ago. And the Welsh Government's rationale for that was simply the COVID pandemic and Brexit before that, which have resulted in delays to bringing forward this legislation. However, the objectives of the bill, as you can see on the screen, there are 6 of them, and I won't go through each of those in any detail, but you can see consistency, certainty, chances of success, quality of applications, confusion, complexity. Those are the driving force behind these changes to the regime, and those stand good as they did in 2018. But it's also important to note that we can't divorce these proposals under the bill from the wider political and technological advancements that are being made in Wales. And we know that there are a number of opportunities in the Celtic Sea for floating offshore wind. We know that Wales has a crucial part to play in decarbonising the economy in line with the UK government's net zero obligations by 2050. And what it's important to ensure is that the consenting regime does not act as a handbrake on the delivery of the key infrastructure that's required to take Wales forward in terms of its plans. What we've also done there is, on that slide, is just to show as well how the planning process in Wales is grinding to a halt almost. So DNS applications before 2020 took 296 days on average, and after 2020 they're taking 440 days. What remains to be seen, of course, is whether the bill will deliver the improvements in timescales that it promises. And finally, before I pass over to Mustafa to talk about the range of projects that fall within the regime and the requirement for infrastructure consent, it's important to say that this bill is in effect a framework bill with much of the detail to be supplemented by secondary legislation. And those familiar with the Planning Act, for example, will know that that's a key element of the Planning Act regime. Much of the detail finds its way into secondary legislation. So alongside the bill, it's going to be important to follow the process of secondary legislation that will give effect to the framework provisions found in the bill. The bill is in 9 parts, the first 2 dealing with significant infrastructure projects. Those are the thresholds that apply to projects within the regime. And then part 2, the requirement for infrastructure consent, which Mustafa is going to talk you through. And then Sarah will deal with later parts of the Act that relate to the timescales and process for applying. So on that, I will pass over to Mustafa.
Thank you, Tom. So the first question that we're going to address is in what circumstances you need an infrastructure consent. As Tom mentioned, the bill doesn't use the language of development consent which is the terminology used under the Planning Act. Instead, it uses the phrase infrastructure consent, and the ministerial statements around this refer to it as a Welsh infrastructure consent, hence WIC, W-I-C. There are 3 circumstances where you will need an infrastructure consent. The first is when the particular development meets the thresholds in the bill for a significant infrastructure project. We're going to spend a bit of time going through those thresholds in detail, but one point worth noting at this stage is that, like the Planning Act 2008, there is a power for the Welsh ministers to amend and add types of development into the category of significant infrastructure project. Like the Planning Act, that includes transport, energy, waste, water, but unlike the Planning Act, it also includes the ability to add projects relating to flood prevention and minerals. So in future, the Welsh ministers might elect to introduce new thresholds for those 2 types of project where they wouldn't necessarily be covered under the Planning Act 2008 regime. The second circumstance where you will need an infrastructure consent is where the Welsh ministers direct a project into the regime. This is the equivalent of a Section 35 direction, which you can obtain under the Planning Act. One of the differences to note, however, is under the Planning Act 2008, Section 35 directions can only be made in respect of developments of a certain kind. So that's all the stuff that you know, transport, energy, but also business and commercial projects. What the bill does is to say that a project can only be directed in where it fits into the kind of development that's specified in regulation, which goes to Tom's point earlier that a lot of the detail here is being left to secondary legislation. The third type of project that needs an infrastructure consent, as it's currently proposed in the bill, is something that is explicitly called out as a significant infrastructure project in the National Development Framework for Wales. It's not clear exactly what kinds of projects will fall into that third category, but there's no equivalent in the Planning Act 2008. So now we're going to move on to some of the detail of the thresholds. Just by way of a preliminary comment, it's worth saying that the DNS regime is largely similar to what's proposed in the bill in terms of thresholds. So what we're doing here is comparing the DCO thresholds that apply in England with the infrastructure consent thresholds that would apply if the bill is enacted as it's currently drafted. The first type of project to focus on is electricity generation, and that includes nuclear projects, but also other kinds of electricity generation projects. In England, if the development is over 50 megawatts, then it must obtain development consent. For the infrastructure consent regime proposed under the bill, it would have to fall between 50 megawatts and 350 megawatts. If it goes above 350 megawatts, the DCO regime is re-triggered. The second type of project to focus on is onshore wind. And what the bill says is that if onshore wind projects generate over 50 megawatts, then they will require infrastructure consent. That's clearly different from the Planning Act 2008 regime, where onshore wind has a very unique position in being entirely excluded and can only be progressed through local planning applications, but the NPPF makes that extremely difficult to progress. On electrical lines, it's worth noting that the thresholds here don't look like Section 15 of the Planning Act. Instead, it says that a infrastructure consent is required where the electrical line has a nominal voltage of 132 kV and it's over 2 kilometres. That differs from the position in England because what's covered under the DCO regime is something which is 132 kVs and above, and then it has a number of different exemptions which apply, which effectively take you outside of the DCO regime. One of those is, for example, the 2 kilometres proviso, but that's still quite different from what's being proposed under the infrastructure consenting regime in the bill, because it's not it's an alternative way of getting outside of the DCO regime rather than something that you need to meet. I'm not going to spend a great amount of detail on some of these, but these slides will be circulated after this session. There are different provisions for fracking and coal mining. The government consulted on expanding the DCO regime to cover fracking back in 2018, 2019, and as yet it's not in the Planning Act regime, whereas it is included in the infrastructure consenting regime proposed under the bill. The roads thresholds are substantively different. In England, projects are caught under a construction or alteration or an improvement, depending on the hectareage for the area of development, but also the speed limit of the proposed highway. That concept of using speed limits is not replicated in the bill. Instead, it says if you're over 1 kilometre of new highway, then that's construction, and otherwise it's effectively looking at whether there's a significant effect on the environment, which in England only applies to the improvement head of highway NSIPs. Moving on, again, I'm not going to go through each one of these line by line, but on rail, it's substantively similar, but some of the exemptions that apply in the DCO regime, for example, where it's carried out within the operational land of a railway operator, are not replicated in the infrastructure consenting regime proposed under the bill. I think that probably means you'll have more rail projects that are caught by the infrastructure consenting regime than you would rail projects caught by the DCO regime in England. Rail freight is substantively similar. Harbour projects, the tonnage and the units are much smaller in the infrastructure consenting regime. That's probably just an indication of the relative size of the harbour facilities in England and Wales, but it also probably means a few more harbour projects will be caught under the Welsh regime than in England. The same general principle applies to airport and aviation projects. So in England, a DCO is required effectively for increasing the capacity of an airport more than 10 million passengers per annum. In Wales, that's 1 million. And then there's a similar kind of cascading reduction for cargo related aviation projects. Radioactive waste is substantively similar, so I won't go into any more detail on that. In terms of what a infrastructure consent can do, as Tom has already mentioned, it's effectively an equivalent of a DCO. So that means it can include compulsory acquisition, it can include the disapplication of consents given the desire to be a one-stop shop, it can include things like traffic regulation. On that point, it's worth emphasising that the position of associated development, which is development associated with the primary development, is rationalised in the bill. So there's a long history of how associated development has been dealt with in Wales. Initially, when the Planning Act was first brought into effect, associated development could not be included in Wales. Instead, you would have to apply for a local planning permission in respect of any associated development. That was the case until the Wales Act 2017, where the position was slightly altered so that associated development could be included for some types of project. What the bill does is effectively removes that unique position of associated development in Wales so that you can, within the confines of the infrastructure consent application, include associated development. That's extremely welcome, and I think it saves having to deal with multiple applications in respect of the associated development. Generally, an infrastructure consent removes the need for planning permission and other consents. It will also be subject to infrastructure policy statements. Again, these are the equivalent of a national policy statement in the Planning Act regime. Enforcement is substantively similar to the Planning Act regime, so it will be a criminal offence not to breach the terms of an infrastructure consent order, and it will also be a criminal offence to implement something which requires an infrastructure consent without having an infrastructure consent order. I'm just waiting for the slide to move on. And then the final point before I hand over to Sarah, who will be talking about the process, is to deal with a relatively common occurrence where projects go across the border between England and Wales. What the bill says is that to the extent the elements of the project are in Wales, infrastructure consent will be required. That is helpful, but it's not entirely clear how it would work in practice. So provided you meet the thresholds for the parts in Wales, you clearly need an infrastructure consent. And I think some of the other details on what that means for any English elements of the project need to be further explained. At that point, I will hand over to Sarah.
Thank you very much, Mustafa. As mentioned, I'm going to say a little bit now about the process that has been created or is proposed to be created by the bill. And as others have already said this morning, this is a framework at the moment. There's a lot of detail that is missing, and so it's necessarily quite a high level explanation at the moment, and we will have to wait and see how the detail thrashes out. But this slide here is just trying to pull out some of the key points on the process and timescales, and then I'll dip into some of it in a little bit more detail. So as we've said, the new regime sort of draws on elements of the DCO regime set up by the Planning Act 2008. But I think it also does draw on the DNS process. So we've talked about some of the shortfalls of the DNS process, but I think what the government in Wales are trying to do is to take the best bits of both processes and create something that will work really well and put Welsh consenting on a really strong footing. And so as you go through the detail, you do see aspects that are familiar to both regimes. And one of the key things that I've picked up on in terms of the legislation is that some of the supporting material seems to talk about moving towards a more DCO style examination where we have hearings and written evidence, whereas the bill itself doesn't necessarily go that far. So we'll have to wait and see what comes out in the legislation, as I'll explain. One of the key drivers, as Tom mentioned, was to provide certainty on timescales, and the bill doesn't actually have very much by way of timescales at the moment, but it does say that the intention is that the final decision on an ICO would be made within 52 weeks from the date of acceptance of an application. So that is that is quicker than a DCO when you think about the pre-examination period for a DCO. So a standard DCO, you would have a 6 months examination and a 6 months decision-making period, whereas here we're talking about trying to achieve everything within that 52-week period. But again, the detail of quite how that will be broken down is not yet clear. In terms of transitional arrangements, it's not very clear. Obviously, if you're working on a project in Wales now, you want to know, when do I need to pay more attention to this? It's not very clear at the moment from the bill exactly what the transitional arrangements might be. Obviously, the bill itself, and Tom's going to talk about the timescales for that at the end of our presentation, but the bill itself will have to pass through the Welsh Parliament, and we will have to have all of the regulations in place and commencement orders, etc. But if you're planning a big project in Wales, it's likely that you're not intending to be applying for your consent for some time, because the inception and early work on these projects takes time. And so obviously it will be very important to understand how the transitional arrangements will work. And if you start going down the DNS regime route and you're complying with the pre-app requirements for that process, how do you gain confidence that if you suddenly find yourself shipped into the new regime, that the work that you've undertaken still counts and that you don't need to sort of start again? So I think that's something that will be important for the regulations to deal with carefully. And I'll just move on to the next slide. So I think I've got a bit of a lag with the slides, apologies, but I think the next slide when it comes up is going to talk about the pre-application process for the new regime. It does, good. So again, this will feel quite familiar to those of you who've worked on DNS and DCO projects, but effectively there are statutory requirements that are going to be imposed, which will involve a formal notification process. And interestingly, the notification process is more like the DNS process, where when you give a formal notification of your application, you actually receive a formal acceptance from the Welsh ministers that notification has been given, which I think can be quite a useful exercise, particularly in the more complex threshold points. So where you may be a little bit uncertain or unclear whether you are in fact pursuing the right consenting process, I think it would be helpful to have that confirmation from the Welsh ministers that the project that you are intending to apply for an infrastructure consent in relation to is in fact caught by the regime, and you can move forward more confidently with that in mind. And the other important thing to note is that the notification that's prescribed in the bill, once that notification is given, any steps you take then can count towards your statutory consultation duties, but anything you do prior to that notification doesn't count. So it's not a formality that you can just do just before you decide to make the submission of the application itself. It's really something you have to do in advance in order that you are formally in the process, and therefore that the consultation activities that you undertake will count towards the statutory test that you will have to meet. And I think I read something in some supporting materials, but I couldn't see it in the bill itself, the possibility of a 12-month period to carry out those activities. I think that's in the DNS regime, so we'll wait to see if that follows in the regulations, but there may well be a period of time specified between which you can give your notification and then subsequently make your application for the order. And again, there's a number of consultation duties anticipated in the bill. Not a lot of detail about that yet. I think all of that will come through in the regulations, but we can expect a sort of front loading of the process like we have in the NSET regime in England and Wales. And there's also a concept that's been introduced in the bill, which is quite an interesting one. There's a provision there about a post-application consultation in respect of any compulsory acquisition requests. And I know this is something that a few people have commented on in their commentary on the bill, and it seems to be that there would be some form of consultation exercise that could be deferred or undertaken once the application is made. I'm not sure if that's the intention. It could just be that this provision in the bill is really designed to deal with the possibility of new compulsory acquisition powers coming forward after you've made the application, which is something that those familiar with the DCO regime will know, that if you add new land rights to a project after you've made an application, you would have to undertake consultation. So it's not quite clear to me what the intention behind that provision is. So it'll be interesting to see when the detail comes forward. And then in terms of the making of the application itself, you make the application to the Welsh ministers, and it has again, familiar to those who are used to the DCO regime, there's an opportunity for the ministers to either accept or reject the application, and that they will have to look at the adequacy of that in order to form that view. Again, it's not fully set out yet, the criteria that they will have to follow in order to decide whether an application is acceptable or not. And I think that will be a mixture of the regulations and no doubt some guidance as well. But the bill does make clear that you have to specify the development, which is probably quite a low bar to start with, but also that you have to include a draft infrastructure consent order. So again, obviously that is very much following the DCO regime, and you will need to prepare an instrument yourself as an applicant and put that forward as part of the process, which is obviously quite different from the position in the TCPA regime. And again, you have to include a consultation report and how you've taken account of the responses that you've received in the context of your consultation. I mentioned at the start that quite how the examination process is going to run is a little unclear from the bill. And if you were to compare the provisions in the bill to, for instance, the 2008 Planning Act, you will see that a lot of detail that was included in that act is not replicated here. And so it does seem that the jury is out, as it were, as to quite how this is going to operate. And perhaps they want to carry out the consultation that Tom's going to speak about at the end and get people's views on that before they confirm quite how the process will run. So if you're a fan of a DCO hearing, it might be the time to express that view. But similar to the DCO regime, there will be an examining authority who will be appointed by the Welsh ministers to look at the application. And again, that could be a single person or a panel of examiners. And they can deploy particular individuals to help them, legal resource or assessors. And they again will decide the procedure that they want to employ to consider the content of the application. And as I've mentioned a few times now, the bill doesn't prescribe compulsory acquisition hearings or open floor hearings or issue-specific hearings. It talks about the conventional planning language of an inquiry, a hearing, or written representations. And it also specifically says that the examining authority can simply determine the application on the basis of its merits and any representations made. So in theory, for a very straightforward project, no hearing or inquiry might be required, but we'll wait to see what the regulations say. And again, as I mentioned, there's not much detail on timescales. This will all have to fit in within that 52-week period that I mentioned a few slides ago, but quite how that's going to break down, I don't know, but I guess you could look at the DNS timescales as an indicator of how that might work. Just to say a little before I pass back to Tom on the decision-making process itself. So the bill prescribes that either the Welsh ministers or the examining authority can make the decision. So that's quite important. Those who were around working in this area when the Planning Act first came in 2008 will recall that the then Infrastructure Planning Commission was originally tasked with determining applications, but ultimately that changed and everything was referred to the ministers for decision making. Here the bill envisages that some projects will be determined by ministers and some will be determined by an examining panel. I'm sure that will be of interest to those who are involved in politically sensitive projects where there may be a desire on the part of ministers to get someone else to make the decision, or alternatively to make sure that they are the decision-making body. But we'll have to wait to see what the regulations say, because they will prescribe the type of projects that should be determined in each case. But it should be noted that the bill also gives the Welsh ministers the ability to step in and say, this project will be determined by us, or alternatively to pass the project over to the examining authority for a decision. The legal challenge provisions are similar to those in the Planning Act, 6 weeks timescale from the decision being made, and it's a judicial review type challenge. So as is usual in planning, you can't challenge the merits of the decision, you have to look to the legalities of it. And we can say more about that if anyone is interested in that point. And I think this is my final slide, which is quite an important one. I think it was mentioned earlier in the presentation that the regime provides for the creation of some infrastructure policy statements. Tom spoke earlier about the complexities and difficulties of working on infrastructure projects in Wales. And I think one of the key challenges that we've found when advising on these projects is the policy basis. Many of the policies do not envisage or are not tailored to some of the larger infrastructure projects, and they can bring real challenges when you try to apply policies that perhaps work very well for smaller developments to these large nationally significant projects. And so the new bill will create a new hierarchy of policy at the top of which will be these new infrastructure policy statements or statement. So that's a really important opportunity to address some of the policy constraints which Welsh projects sometimes suffer from. And it'll be interesting to see when the infrastructure policy statement comes forward, because until it does, this provision is pretty useless. But if we can get a good strong IPC in place, sorry, it should be IPS on the slide, I see a typo there, but IPS in place, that will make a huge difference at the decision-making stage. And otherwise, the decision-making provisions in the bill are pretty similar to those for DCOs. You have to determine in accordance with that policy statement and the other matters listed, and that the exceptions to that are really down to legality. So if there's going to put something in breach of international obligations or other enactments, and in addition, the test of adverse impact that would outweigh the benefits. So even where you have very, very strong policy support, you will still have to demonstrate that the adverse impacts do not outweigh the benefits that your project would bring. So that qualitative assessment of the benefits and impacts of a scheme will always still be critical. And the final point from me is that I think it might be mentioned, but there's also the introduction of, in addition to local impact reports, marine impact reports. So again, those familiar with the DCO regime will be familiar with LIRs, which are a local authority's opportunity to set out the impact of the project in their administrative area. And the marine impact report is a new mechanism which will allow the same to happen for the marine area within which a project is proposed. And with that, I'm going to hand back to Tom, who's going to talk a little bit more about the bill process before we wrap up.
Thanks again, Sarah. Okay, that was much quicker this time to go through to the next slide. So for those who don't know anything about bill process in Wales, like me before preparing these slides, the bills have to go through 4 stages to become law in Wales. And because there isn't the bicameral system that we have in Westminster, on the face of it should be quicker. That said, we are only at stage 1 of the process. And we've had 1 committee hearing so far, which considered the general principles of the bill. And I'll come on in a moment to describe the consultation that the committee has now launched on the bill. Stage 2 involves detailed consideration of the bill by a committee. Following that detailed consideration, it goes back to the Senedd for consideration. And then stage 4 involves a vote by the Senedd to pass the final text of the bill, and all bills in Wales must receive royal assent as well. In terms of the timescales, well, it's difficult at this stage to say when this bill might become law. I know that the bill itself refers to the Infrastructure Wales Act 2024, which may give an idea as to what they're thinking, but equally, it would be no surprise to me if this bill took longer than that to become an act. And then just finally, I mentioned the consultation. So the Climate Change, Environment and Infrastructure Committee, which is the committee that's been appointed to consider the general principle of the bill, has recently launched a consultation. Now, this is a public consultation that is open to everybody to engage with. responses must be submitted online by the deadline on Friday, the 11th of August. And it's a wide-ranging consultation that basically covers every single aspect of the bill, should you wish to comment on it. And it seems to us that there are numerous issues that you may want to discuss. And I can see on the Q&A there was already a question around the absence of hydrogen in the bill. So things like that, for example, could quite well form the basis of a consultation response. Once that consultation has ended, there'll be a brief pause for the summer, and I know that the committee are going to sit again in mid-September, I think, to again consider the general principles of the bill before it moves through to stage 2 of the process. So that's everything I wanted to say about process, and it gives us some time, I think, to consider any questions.
Thank you, Tom. We do have some questions coming in, and I will. What we'll do, please do keep your questions coming. We've got a bit of time to speak to those now. If there are more questions that come in than we're able to answer, then we will follow up after the webinar and answer any questions that are outstanding. But I'll kick off with the first question that came in. There is no mention of hydrogen projects in the bill currently, with a number of green and blue hydrogen projects coming forward, particularly in West Wales. Do you think this could be a type of project which would be a SIP, particularly with section 17, which gives powers to add, vary or remove types of SIPs? Tom, you've commented on hydrogen, do you want to answer that?
I can, yeah. I mean, I think that is a type of project that could be amenable to a clause 17 direction, because it's in the field of energy. A couple of other points I would note, though, is that there's the power, as Mustafa said, to bring certain projects within the regime under clause 22 of the bill, and that's similar to a section 35 direction under the Planning Act. And again, that would be a more project-specific basis for bringing a project within the regime, and that can be done in relation to energy projects. But I think more widely, it's surprising that hydrogen isn't in the bill at all already. It seems to me that is, for anybody interested in hydrogen, that's certainly something that could, form the basis of a very sensible response to the consultation. Why not include hydrogen type projects as a specific type of infrastructure that's included in the bill and has thresholds associated with it, so that the certainty is provided up front rather than waiting for later decisions to be made, bringing it within the regime.
Thank you, Tom. Just on that point, I seem to recall that when the 2008 Act was going through Parliament, there were additional categories of NSIP added on the basis of representation. So I think there really is value in trying to influence that process at this stage. And as someone who works quite heavily in the flood defence arena, I did think it was interesting that flood defence was mentioned as a field in respect of which projects might come forward, but no detail in the bill as to a sort of an initial assessment of what an appropriate flood defence project might look like, which seems like a bit of a missed opportunity to my mind. For those interested in that. Just looking then at the questions, I'll take this one. So will the DCO regime still apply in Wales once the IC regime is enacted for projects that fall outside the IC, such as pipelines, etc.? Yes, that's right. So the two regimes will sit in tandem together. So what's required in each case is a careful analysis of the thresholds that Mustafa talked us through earlier, to understand what you're doing and the extent to which it might sit within the Planning Act 2008 regime and the extent to which it might sit within the new regime. And in each case, that does, where there's any doubt about that, you have to look at that quite carefully. And we touched on the cross-border issue and the bill's treatment of that, which is an area again that we think there could be some room for improvement in terms of how cross-border projects might be consented and treated, as compared to where the bill has started on that. And then for the next question, there's a couple of questions actually about the IPSs that I think Mustafa's going to take. So perhaps I'll just hand over to you, Mustafa, and you can just, I think there's 2 or 3 on a similar line, so perhaps you could pick those up together.
Thanks, Sarah. So just to summarise the questions that have come through. So the first is whether infrastructure policy statements will be similar to national policy statements. And then the supplemental question is the intention to have multiple infrastructure policy statements or a single infrastructure policy statement? The bill itself doesn't specify in particular how many infrastructure policy statements there are going to be. The provisions are drafted like the provisions relating to national policy statements. However, if you go back to the consultation that was held prior to the introduction of the bill in 2018, there is a helpful statement there where they say, where necessary, additional topic-based policy statements will be developed, and these will be the main consideration, particularly for areas which the National Development Framework or the Welsh National Management Policies does not cover. So I think that's part of the detail that we need to see, but the indication seems to be that they will be sector focused and there are likely to be multiple, but unlike the Planning Act regime, they might elect not to introduce them where they think the national development frameworks cater for those responses. And I think that also deals with another question, which is, will there be one infrastructure policy statement for each type of development, or whether they'll have overarching ones? I think on that particular point, I would just make the comment that in the Planning Act regime, we obviously have two types of broadly national policy statement. The site-specific national policy statement, so the best example of that is the Airports National Policy Statement, which is primarily intended to be for Heathrow expansion. And then we have national policy statements which are not site-specific at all, such as the Ports National Policy Statement or the National Networks National Policy Statement. I think each one of those has its benefits. I think that will vary from sector to sector. But the other point is we also have another distinction in the existing Planning Act 2008 regime, which is the energy national policy statements, for example, have an overarching one, and then they have effectively sub-national policy statements, which are sector specific. I think there have been discussions in the past about whether you need one overarching national policy statement or an infrastructure policy statement, which applies to all development. And then you just have sector specific ones, which deal with very specific matters relating to that type of technology. I personally don't think that's doing anything other than restructuring a national policy statement or an infrastructure policy statement. And I think the disaggregation by sector is actually probably quite helpful, because there are subtle differences that arise, which are not technology specific, but are sector specific. I think the next question, which I will read out, is, do you anticipate the secondary legislation will be consulted on? I don't know if Tom or Sarah, you'd like to pick up on that?
I can do. I think I read in the explanatory memorandum to the bill that the Welsh Government will consult on secondary legislation where necessary. So quite where they'll put the line, I don't know, but I think that probably indicates that in respect of secondary legislation that potentially has controversial aspects to it, or aspects that are debatable or on the fringes of engaging public interest factors, then they will. And for the more benign secondary legislation, I suspect it will just be waved through.
Thanks, Tom. The questions are coming in reasonably thick and fast, which is fantastic. I'm just looking at the time and sort of trying to pick through ones that might touch on topics we haven't talked about yet. As I say, we will make sure we reply to everything. So if we don't reply to your question now, we will get back to you. There's a question, I think, about the marine licensing regime, which I just thought we should touch on. So I'm just trying to find it now, moving around. Is there any indication that the planning process will be linked to the marine licensing regime, with the Welsh adopting a system similar to deemed marine licenses, or will there still be two separate systems? So that is dealt with in the bill, and it is clear that the new process will enable deemed marine licensing provisions to be added into the infrastructure consent order. So that is a huge advantage to this new regime over the DNS regime, where you obviously still have to, and it goes to this one-stop shop point that we've spoken about. So hopefully that's good news for Trevor, who asked that question. And I'm just looking to see if there's any specific questions that touch on new issues that we should take time to talk about. There's an interesting question here about if there's any merit on a project which has no time and budget constraints to wait for the bill to be enacted and apply for an infrastructure consent. I guess the jury's probably a little bit out on that one, but I'm very interested in this project that doesn't have any time or budget constraints. I mean, I think obviously the government's intention is that this new regime will be better than the regimes that are in place now. I suppose from our experience as planning lawyers, new regimes can be a little clunky, and there does often need to be a period of bedding in and time for things to be tweaked and adjusted. You would hope that because this is building onto prior regimes that may not be so necessary, but I guess our advice would be that you may want to just get on, because as Tom alluded to, these processes can take time to go through. The legislation can take time to go through. The secondary legislation will take time to go through, and who knows what political changes might happen in the meantime, and where the regime might end up. So unless there's a real issue with the existing process for you, so if you're facing a real policy or other constraint with the existing process, that would mean that there would be a driver to wait, then I would expect that you want to press on with your project development and your consenting process, because it would be a real shame if the nature of the consenting process drove your programme, which would be sort of tail wagging the dog to my mind. I might see if Tom or Mustafa want to pick up on any of the other questions, because they've probably been looking at them while I've been speaking.
There is a question about the optional significant infrastructure project thresholds, and it's worth saying, so this was in the detail of the table, but for onshore wind, as I mentioned, in England it's effectively excluded from the Planning Act regime. Under the bill, what's proposed is if it's over 50 megawatts, you must get a infrastructure consent for onshore wind. But if it's between 10 and 50 megawatts, or it's an existing alteration, then there's an optional route to go down the infrastructure consenting route. That is quite interesting, and it's not something that we've experimented much with under the Planning Act 2008 regime, but that's effectively the position on the optional thresholds. I'm just looking through the other questions. There's a question here which is, how does this work with reserved powers such as nuclear? And I think Sarah's comment earlier, which is the DCO regime and the infrastructure consenting regime as proposed are to work in tandem, is effectively the answer to that. So the current position in Wales is that if a project is over 350 megawatts for nuclear projects, then it would require a DCO. It was on that basis that the Wilver Horizon nuclear project was seeking to obtain a DCO. So all of the things which are DCO threshold will continue to apply. What this is intending to do is set thresholds for the infrastructure consenting regime, which is below, except that odd position I mentioned with onshore wind, for the infrastructure consenting proposed under the Welsh bill.
I think there was another question that came in around whether there's an indication in the bill of what the requirements of statutory consultation will be. Will there be a requirement for consultation on preliminary environmental information? And I think the answer is no, but this is one of the matters that will be addressed by the secondary legislation that I referred to, and I can't see any reason why that won't be very similar to the approach in under the DCO regime. So statutory consultation for a minimum of 28 days with the provision of a peer and notices in the normal way. And I suspect that will all have to be compiled into the form of a consultation report that gets submitted with an application and is considered as part of the decision to accept or refuse an application for examination.
Thanks, Tom. There's also a question in here about health considerations. From a public health point of view, it would be useful to have clarity on such considerations in the IPS, similar to the NPS. Health is not a statutory consultee in Wales. I mean, again, I think that's the sort of point that might be quite useful to, if you were inclined to make a response to the consultation that Tom has mentioned. Although that consultation is not looking at the policy statements yet, I think the sooner you can start getting minds focused on the types of issues that you think ought to be addressed, the better. And as indeed the commenter, the questioner has noted, health is something that is mentioned in other national policy statements under the 2008 Act. So I would fully expect that it would be covered, and it does seem to be, certainly in my experience as an infrastructure consenting lawyer, an increasingly important area. So I would be surprised if there weren't provisions relating to health impacts in the appropriate policies. And in fact, I'd just pick up on one small point, I think, which was a sort of add-on to one of the questions that we did answer, but possibly not this aspect of it. I think I might have dealt with it in the presentation, but if there is no relevant policy statement in place, the position is simply that the application is determined in accordance with the other policies that are listed in the section in the slides. So again, it would look at the development framework and the existing policy regime in Wales. It's just that when you get the national policy in place, that will trump those policies. It will be more infrastructure focused, potentially sectorally infrastructure focused, and no doubt more helpful to those trying to understand how to assess and make the case for their scheme. So as we've found with the DCO regime, the full benefits of the process are not really realised until the policy statement is in place. I'm looking at my colleagues here to see whether we may have answered all of the questions on the chat. We will go back through them carefully and make sure, but I'm conscious that it's 10:28 and everyone will have a busy day. So I think I may wrap it up there. Thank you very much for joining us today. Thank you very much for the questions that have come in. It's appreciated. The final slide there has our contact details. We will circulate the slides to everyone in attendance. Please do let us know if you have any questions that you haven't asked today. We're very happy to talk to you about the bill, very happy to help you with any consultation responses you might be intending to make, and indeed very happy to have another session like this for you or your colleagues or your organisation if that would be of interest. So thanks again for joining us today.